The automated email arrived in my encrypted inbox at exactly 8:14 p.m. on a Thursday. The subject line was plain, generated by a municipal server, but the implications of the text were severe. It was a notification from the county recorder's automated title fraud alert system, a free digital monitoring service I had activated 5 years ago. The alert indicated that a new lien had just been electronically filed against Parcel 409-B. Parcel 409-B was not a residential home. It was 12 acres of commercially zoned, undeveloped land situated less than a mile from the new interstate expansion. I had purchased it in cash 7 years ago during a municipal auction. It carried 0 encumbrances, 0 mortgages, and a clean, unblemished title. Its current appraised market value was slightly over $1.2 million. It was the anchor asset of my investment portfolio, sitting quietly and appreciating in value while the city expanded toward it. I did not panic. I did not immediately reach for my phone to call my attorney. Panic is an uncontrolled emotional response that clouds judgment, and in cases of asset vulnerability, clarity is the only tool that matters. I set my coffee mug down on the kitchen island, opened my laptop, and logged directly into the county clerk's secure public portal. I paid the $20 expedited digital retrieval fee and downloaded the newly recorded PDF document. The file was 22 pages long. It was a deed of trust to secure bail, a specific legal instrument used to pledge real estate as collateral to guarantee a criminal defendant's appearance in court. I scrolled down to the defendant's information. The name printed in stark black ink was Jackson Miller. The charges listed were 3 counts of commercial wire fraud and 1 count of receiving stolen property. The presiding judge had set his bail at $250,000. In our jurisdiction, utilizing real estate for a property bond requires the asset to have unencumbered equity equal to exactly twice the bail amount. Jackson needed $500,000 in clear equity. Parcel 409-B covered that requirement with over $700,000 to spare. I scrolled to the surety information, the person legally pledging the land. The name on the line was Chloe Vance, my younger sister. Below her printed name was a signature. It was supposed to be mine, granting her full power of attorney to encumber the property. I zoomed in on the digital ink. It was a remarkably clean trace job, likely copied from an old tax return or a shared family document she had photographed. Beside the forged signature was a digital notary stamp, authenticating the document under penalty of perjury. The mechanics of her betrayal clicked together with cold, undeniable logic. Chloe had been dating Jackson for 8 months. He was a chronic grifter who funded his lifestyle through corporate shell companies and fraudulent invoices. Chloe was his chronic enabler, constantly making excuses for his behavior, blinded by a desperate need for validation. When Jackson was finally indicted and arrested, Chloe lacked the liquid cash to hire a bail bondsman who would have required a non-refundable $25,000 fee. Instead, she decided to use my financial stability to subsidize his criminal liability. She assumed the county clerk's office, overwhelmed with thousands of daily filings, would not thoroughly verify a digital notary stamp on an electronic submission. She assumed she could quietly pledge my land, Jackson would be released, he would show up for his trial, and the lien would eventually be dissolved without me ever knowing it had been placed. She treated my primary commercial asset like a temporary credit card. A weaker person would have immediately dialed Chloe's number, screaming and demanding an explanation. A weaker person would have driven to her apartment to confront her, giving her the opportunity to cry, manipulate the situation, or hastily attempt to withdraw the filing before the legal consequences solidified. I did not call her. I closed the PDF and disconnected from the municipal portal. If I confronted Chloe now, the issue remained a private family dispute. She could claim she was confused by the paperwork or that Jackson's associates had pressured her into the forgery. She would escape the full weight of the justice system. But to finalize a property bond of this magnitude, the paperwork had to be formally presented, reviewed, and approved by a sitting judge in open court. I checked the county criminal docket. Jackson Miller's bail review hearing was scheduled for tomorrow morning at 10 a.m. in courtroom 3B. That was the exact moment the trap would snap shut. Presenting a forged document to a federal or state judge to secure the release of an indicted felon elevates the crime from simple identity theft to felony perjury, fraud upon the court, and attempting to defeat the administration of justice. I was not going to stop her from making the attempt. I was going to let her walk the forged document all the way to the judge's bench. The next morning, I woke up at 6 a.m. I dressed in a tailored charcoal suit, attire selected specifically to convey complete professional authority in a judicial environment. I drove to my primary bank branch right as the doors unlocked at 8 a.m. I bypassed the tellers and requested immediate access to the secure vault. The branch manager escorted me to the subterranean level, where I used my key and biometric scan to extract my safe deposit box. Inside the steel box was a fireproof sleeve containing the foundational documents of my estate. I bypassed the corporate charters and the emergency cash reserves. I reached for a thick, heavy-stock manila envelope. Inside the envelope was the original, physical deed of conveyance for Parcel 409-B. It was not a digital printout, it was the master document. It was printed on archival-grade watermarked security paper. At the bottom of the final page, overlapping my authentic signature in blue ink, was the raised tactile intaglio seal of the county clerk's office, physically embossed into the fibers of the paper on the day of the cash purchase 7 years ago. It was an undeniable, unforgeable physical artifact proving complete, unencumbered ownership. I placed the original deed into my leather portfolio. I locked the safe deposit box, returned it to the vault, and walked out of the bank. The morning air was crisp and clear as I drove toward the county courthouse. Chloe believed she had orchestrated a flawless, victimless crime. She believed she was about to sit in the gallery and watch her boyfriend walk out of custody, financed by my hard work. She had no idea that the owner of the collateral was currently walking through the courthouse security detectors, holding the physical evidence required to completely dismantle her life. I checked my watch. It was 9:45 a.m. I walked toward the heavy oak doors of courtroom 3B, ready to let the legal machinery process her treason. The heavy oak doors of courtroom 3B swung open silently on their oiled brass hinges. The interior was a cavernous space of dark wood paneling, worn carpeting, and the low, persistent hum of the central HVAC system. It was an environment designed to strip away individual ego and enforce the rigid hierarchy of the judicial process. I walked down the center aisle, my leather portfolio secured firmly under my right arm, and took a seat in the third row of the public gallery. I did not sit directly behind the defense table. I chose a vantage point near the aisle, offering a clear line of sight to the bench, the bailiff's station, and the prosecution. At 9:55 a.m., the side door near the holding cells opened. 2 county sheriff's deputies escorted Jackson Miller into the courtroom. He was wearing an orange Department of Corrections jumpsuit, his wrists secured in standard, steel transport cuffs chained to a belly belt, his usual arrogant swagger, the demeanor he employed to charm investors and manipulate women like my sister, was noticeably diminished by the sterile reality of the penal system. He was directed to sit beside a tired-looking public defender who was rapidly reviewing a thin stack of legal files. 2 minutes later, Chloe walked through the main gallery doors. She wore a tailored beige blazer and dark slacks, an outfit clearly selected to project an aura of responsible, upper-middle-class stability. She walked with a noticeable lightness in her step, a manufactured confidence born from the delusion that she had successfully outsmarted the system. She took a seat in the front row, directly behind Jackson. As he turned his head to look at her, she offered him a warm, reassuring smile and a subtle nod. She was entirely convinced that her fraudulent electronic filing from the previous evening had bypassed all municipal scrutiny. She believed She was the savior of the morning. She did not scan the room. She did not look over her shoulder. Her focus was entirely locked on the man she was attempting to rescue. She remained completely oblivious to the fact that the legal owner of the 12 acres she had just pledged was sitting less than 20 feet away. At exactly 10 a.m., the door behind the elevated wooden bench opened. "All rise!" the bailiff commanded, his voice echoing cleanly off the walls. Judge Harrison took his seat. He was a veteran jurist with a reputation for zero tolerance regarding procedural anomalies and docket delays. He adjusted his reading glasses, opened the master ledger on his desk, and immediately began calling the morning calendar. Docket number CR-23-884, Judge Harrison read into the microphone, his tone entirely transactional. State of New York versus Jackson Miller. Charges include 3 counts of commercial wire fraud and 1 count of receiving stolen property. The court previously set bail at $250,000. Counsel, I see a motion for a property bond was filed electronically late yesterday evening. State your appearances. The public defender stood up, adjusting his tie. Mark Jenkins for the defendant, Your Honor. We are formally presenting a deed of trust to secure bail, utilizing a commercial parcel located within county limits as collateral. And the prosecution? Harrison asked, looking over his glasses at the assistant district attorney. Sarah Collins for the state, Your Honor. The ADA replied, standing up. We have reviewed the electronic filing. The county tax assessor's database confirms parcel 409-B has an appraised market value of $1.2 million. A title search pulled this morning indicates 0 outstanding liens or encumbrances. The equity threshold is met. Provided the surety is present in the courtroom to verify the pledge under oath, the state has no formal objection to the bond. Chloe shifted in her seat, her shoulders dropping in a clear display of relief. She had cleared the primary hurdle. The prosecution had accepted the digital paperwork. The trap she had built for herself was now fully armed and waiting for the final trigger. Very well, Judge Harrison stated, turning his attention to the gallery. Is the surety present? The individual pledging the property must approach the podium. Chloe stood up. She smoothed the front of her beige blazer, projecting an image of total composure, and walked through the swinging wooden gate that separated the gallery from the well of the court. She approached the central podium, her hands resting confidently on the edges of the wood. State your name for the record, Judge Harrison instructed, picking up his pen. Chloe Vance, Your Honor, she answered, her voice clear and unwavering. Ms. Vance, you understand that by pledging this commercial property, you are guaranteeing the defendant's appearance at all future court dates? Harrison asked, looking directly at her. If Mr. Miller fails to appear, the county will execute a foreclosure on parcel 409-B, and you will forfeit the asset entirely. Do you comprehend the severity of this financial commitment? I do, Your Honor, Chloe replied smoothly. She didn't hesitate. She was pledging an asset she didn't own, risking a financial empire I had built, all to secure the release of a chronic grifter. The depth of her betrayal was staggering, yet she wore it with total ease. Harrison looked down at the printed copy of the electronic filing on his desk. The deed lists the primary title holder as... Harrison paused, his eyes scanning the digital signature line. It appears the property is solely titled under a different first name. You are acting as the authorized agent for the property owner? Yes, Your Honor, Chloe lied, her voice remaining perfectly steady. She had rehearsed this. My sister is the sole title holder. We manage our real estate portfolio together. She signed a full power of attorney yesterday, granting me the legal authority to encumber the parcel for this specific bond. The notarized authorization was included in the electronic filing packet. Judge Harrison flipped to the last page of the document. He examined the printed digital notary stamp and the forged signature. To the naked eye on a standard black and white court printout, it looked like a standard legally binding administrative transfer. He reached for his wooden gavel, prepared to strike the sounding block and finalize the release order. Jackson Miller let out a breath he had been holding, turning to look at Chloe with a triumphant smirk. Chloe smiled back, the victory fully cemented in her mind. She had won. She had beaten the system, utilized my hard work, and suffered zero consequences. I unzipped the heavy brass zipper of my leather portfolio. The metallic sound was sharp and distinct in the quiet courtroom. I stood up from the wooden bench in the third row. "Your Honor," I stated clearly, my voice slicing through the procedural silence, carrying the freezing, undeniable weight of true ownership. "The court is currently reviewing a fraudulent document. I am the sole owner of Parcel 409-B. I did not authorize this bond, and the signature on that paperwork is a felony forgery." Chloe froze. The triumphant smile vanished from her face instantly, replaced by a look of sheer, unadulterated terror as she turned around and saw me standing in the center aisle. I did not raise my voice, nor did I display any emotional distress. The mechanics of the courtroom required strict adherence to facts. The assistant district attorney turned sharply, her professional demeanor instantly replaced by heightened alert. The public defender physically stepped away from his client. The gravity of the judicial system was about to collapse entirely upon her. The echo of my voice hung in the cavernous space of courtroom 3B. Judicial environments are specifically engineered to maintain strict procedural order. Sudden interruptions from the public gallery are immediately treated as hostile disruptions. The bailiff, a heavy-set sheriff's deputy standing near the holding cell door, instantly unclipped the retaining strap on his duty belt and stepped forward, his eyes locking onto my position in the third row. Judge Harrison did not shout or strike his sounding block. He possessed the seasoned composure of a man who had presided over thousands of criminal proceedings. He lowered the printed electronic file, removed his reading glasses, and fixed his gaze squarely on me. "Ma'am," Judge Harrison stated, his tone carrying a freezing administrative warning. "This is a formal bail review hearing. Unsolicited outbursts from the gallery result in immediate removal from the courthouse and potential citations for contempt. If you have a civil claim regarding this property, you must file an injunction with the county clerk's office on your own time." "I am not here to file a civil injunction, Your Honor," I replied, maintaining a perfectly level, unyielding volume. I stepped out of the wooden pew and walked down the center aisle toward the swinging gate that separated the gallery from the well of the court. "I am here to prevent the state of New York from inadvertently facilitating a felony. The woman standing at the podium, Chloe Vance, has submitted a digitally forged power of attorney. She does not own the commercial collateral. She has no legal authority to encumber it, and I possess the physical documentation to prove her perjury." Chloe was paralyzed. Her hands gripped the edges of the wooden podium so tightly her knuckles turned a stark, translucent white. The manufactured confidence she had projected less than 60 seconds ago had completely evaporated, replaced by the physiological onset of severe, unmitigated panic. She turned her head slightly, her eyes wide, silently begging me to stop walking, to turn around, to maintain the family secret and let the grift proceed. I did not look at her. I stopped at the wooden gate, keeping my posture rigid, and looked directly at the bench. "Permission to approach the clerk, Your Honor," I requested, utilizing the exact procedural terminology required to navigate the restricted space. "I have the original unencumbered deed of conveyance for Parcel 409-B. Judge Harrison evaluated the situation. A civilian attempting to interrupt a bond hearing was highly irregular, but the specific, detailed allegation of a forged title document being used to secure the release of an indicted felon was a critical procedural vulnerability. He could not ignore a direct claim of fraud upon the court. He looked at the assistant district attorney, who gave a brief, tight nod, signaling her own sudden suspicion regarding the unverified electronic paperwork. "Approach the clerk," Judge Harrison commanded. "Bailiff, secure the center aisle." I pushed through the wooden gate. I walked past the defense table, where Jackson Miller was sitting in his orange Department of Corrections jumpsuit. The arrogant smirk had vanished from his face entirely, replaced by a dark, calculating scowl. He understood the mechanics of financial leverage better than anyone. He knew instantly that the collateral had just collapsed. The public defender, sensing the impending legal disaster, physically leaned away from his client and began rapidly shuffling his own notes, preparing to distance himself from the fraudulent filing to protect his own license. I stopped precisely 2 feet to the left of the podium where Chloe was standing. I could hear her breathing, shallow, rapid, terrified intakes of air. I unzipped the heavy brass zipper of my leather portfolio and extracted the thick manila envelope. "Your Honor," I stated, retrieving the master document. "The electronic file submitted to this court late yesterday evening relies on a digital notary stamp and a flattened traced signature. It is an unverified, easily manipulated PDF. What I am handing to the bailiff is the original physical deed of conveyance, executed 7 years ago during a municipal cash auction." I handed the document to the bailiff, who carried it up the steps to the judge's bench and placed it on the polished wood. "You will note the physical properties of the document, Your Honor," I continued, narrating the audit as Judge Harrison placed his glasses back on and flattened the heavy paper onto his desk. "It is printed on archival-grade security paper, featuring a proprietary municipal watermark visible under standard light. Furthermore, the signature in the bottom right quadrant is not a digital vector. It is wet, blue ink, and overlapping that ink is the tactile raised intaglio seal of the county clerk's office, physically embossed into the fibers of the paper. That specific seal cannot be digitized, duplicated, or transferred through an electronic portal." Judge Harrison ran his thumb over the bottom right corner of the paper. The distinct abrasive texture of the embossed municipal seal was undeniable. It was the analog anchor of true ownership, a physical artifact that no PDF could ever replicate. He then picked up the printed copy of Chloe's electronic filing and placed it side by side with my master document. The silence in the courtroom grew dense and suffocating. The air conditioning hummed, but no one moved. The assistant district attorney stepped toward the center of the well, her eyes fixed on the bench, realizing the state had been mere seconds away from releasing a high-risk defendant based on a fabricated lien. Judge Harrison's demeanor underwent a total transformation. The administrative neutrality vanished. The seasoned jurist realized he had just been lied to directly, on the official record, by a civilian attempting to manipulate his courtroom. "Ms. Vance," Judge Harrison said. He was not speaking to me. He was addressing Chloe. The temperature in the room seemed to plummet. "You stood before this bench less than 3 minutes ago and explicitly stated, under oath, that you possessed a valid notarized power of attorney to encumber this commercial asset." Chloe opened her mouth, but her vocal cords failed to produce a sound. She looked at Jackson for support, but he was staring at the table, entirely unwilling to associate himself with her failure. She looked at me, her eyes brimming with tears of sheer desperation. I thought," Chloe stammered, her voice a fragile, broken whisper echoing through the microphone on the podium. "It's my sister's land. We are family. I thought she wouldn't mind if I just used it temporarily to get him out. He promised he would go to trial. I was going to take the lien off later. It was just temporary." She had just confessed, in open court, on the official audio record surrounded by sworn officers of the law. "You thought she wouldn't mind?" Judge Harrison repeated, his voice dropping into a register of freezing, unequivocal judicial wrath. He slowly picked up the fraudulent electronic printout and held it in the air for the entire courtroom to see. "You utilized a municipal server to file a fraudulent lien against $1 million commercial property. You forged a signature. You misappropriated a digital notary stamp. And then you walked into a court of law and committed perjury in a calculated attempt to secure the release of an indicted felon facing federal wire fraud charges." The judge dropped the paper back onto his desk. The sound of it hitting the wood was remarkably loud. "Counselor," Judge Harrison snapped, looking directly at the assistant district attorney. "The property bond is categorically rejected. The defendant, Jackson Miller, remains remanded to county custody without bail. He is a demonstrated flight risk whose associates are actively engaged in attempting to defraud this court." Jackson Miller cursed under his breath as the two sheriff's deputies immediately stepped forward, grabbing his arms to escort him back through the side door to the holding cells. He didn't look back at Chloe. His primary source of funding had just been neutralized. But the judge was not finished. He turned his gaze back to the podium, where Chloe was standing, trembling so severely she had to grip the wood to remain upright. "As for you, Ms. Vance," Judge Harrison pronounced, the legal machinery fully engaging its gears to crush her, "you are no longer considered a surety in this courtroom. You are now a suspect." The silence in the courtroom following Judge Harrison's declaration was total. Judicial authority is not a concept debated in the well of a court. It is a physical force executed by armed deputies. The heavy-set bailiff, who had been standing near the holding cell door, walked deliberately toward the wooden podium where Chloe was standing. He did not ask her to turn around. He reached out, grasped her left arm just above the elbow, and turned her physically away from the judge's bench. "Hands behind your back," the bailiff instructed, his voice a low, practiced monotone. Chloe's beige blazer bunched at the shoulders as she instinctively resisted, pulling her arm forward. It was a futile, reflexive action of a person who had never faced a physical consequence in her entire adult life. The bailiff did not negotiate. He applied a standard compliance hold, forcing her wrists together behind her back. The sharp, metallic ratcheting sound of the steel handcuffs locking into place echoed cleanly off the dark wood paneling of the gallery. "Wait! No, please!" Chloe gasped, her voice cracking as the cold steel bit into her skin. "I'm not a criminal. I didn't steal anything. The land is still there. You can just cancel the paperwork. We can just withdraw the filing right now." She looked wildly at the assistant district attorney, expecting the prosecutor to understand her logic. She fundamentally misunderstood the mechanics of the justice system. The crime was not the successful theft of the land. The crime was the attempt, the forgery, and the perjury committed under oath. The system does not offer refunds for failed fraud. "Your Honor," the assistant district attorney said, stepping forward, entirely ignoring Chloe's panic. "The state requests that the defendant, Chloe Vance, be remanded to county custody, pending arraignment. The preliminary charges include felony forgery in the second degree, offering a false instrument for filing in the first degree, and perjury. We also request that both the electronic printout of the fraudulent deed and the original deed of conveyance provided by the property owner be impounded by the clerk as primary physical evidence for the upcoming grand jury." Judge Harrison nodded, making a swift notation in his master ledger with a fountain pen. "Granted. The clerk will secure the original deed of conveyance and issue a certified receipt to the property owner. Furthermore, the electronic lien filed against parcel 409-B is hereby quashed and expunged from the county records by direct judicial order. The title is officially restored to its unencumbered state." He looked down at Chloe, who was now weeping openly, her tears dropping onto the polished wood of the podium, staining the varnish. "Ms. Vance," Judge Harrison pronounced, his tone devoid of any sympathy or hesitation, "you attempted to utilize the infrastructure of this court to facilitate a felony. You treated a legal proceeding as a mechanism for your own convenience. You will be held without bail until your formal arraignment tomorrow morning." The bailiff began to guide Chloe toward the side door leading to the holding cells, the exact same heavy door Jackson Miller had just been escorted through minutes prior. As she was forced to walk past the swinging wooden gate, she stopped, digging the heels of her shoes into the worn carpet. She looked directly at me. Her face was flushed, her carefully applied makeup ruined by tears, her eyes wide with a mixture of terror and misplaced betrayal. "How could you do this?" Chloe sobbed, her voice echoing painfully in the quiet room. "I am your sister. You have millions of dollars. You don't even use that land. It just sits there. I just needed it for a few months to save him. You could have just let it go. You are sending me to jail over a piece of dirt." I stood in the center aisle, holding my empty leather portfolio. I did not raise my voice. I did not display anger, sorrow, or vindication. I observed her with the cold, analytical detachment of an auditor finalizing a compromise ledger. "I did not send you to jail, Chloe," I stated, the acoustics of the courtroom carrying my words with chilling clarity. "I simply provided the court with the accurate documentation regarding Parcel 409-B. You chose to bypass a notary, forge a signature on a legal instrument, and commit perjury in front of a sitting judge to subsidize the liabilities of a chronic grifter. The land is a commercial asset. It is not an emergency fund for your collateral damage. You engineered this outcome entirely on your own." "You're a monster," she hissed, the desperation turning into venom as the reality of her incarceration solidified around her. "You care more about a piece of paper than your own flesh and blood." "I care about structural integrity," I corrected her smoothly. "And you are a demonstrated liability. The system is simply correcting the error you introduced." I turned my back on her before the bailiff even resumed his grip. I did not watch her being pulled through the side door. I did not listen to the heavy steel door slam shut, securing her inside the county holding facility alongside the very man she had tried to save. I walked directly to the court clerk's desk, situated just below the elevated bench. The clerk, a woman with meticulous organizational skills, had already filled out a secure evidence receipt. She stamped it with the official date and handed it to me across the counter. "The original deed is secured in the primary evidence vault," the clerk confirmed quietly, maintaining the hushed tone required in the courtroom. "The expungement order for the fraudulent lien has been electronically transmitted to the county recorder. Your title is completely clear as of this minute." "Thank you," I replied, placing the receipt into my portfolio and zipping the brass closure shut. I walked back down the center aisle of courtroom 3B. The gallery was entirely silent. The public defender was staring at his legal pad, actively calculating the damage to his own schedule and how quickly he could file a motion to withdraw as Jackson's counsel. The assistant district attorney was organizing her files, preparing for the sudden influx of felony paperwork she now had to process. I exited through the heavy oak doors, stepping out into the brightly lit, bustling hallway of the county courthouse. The air was thick with the low murmur of lawyers negotiating plea deals, bail bondsmen pacing the tile floors, and defendants waiting for their names to be called. I walked past them, entirely insulated from their chaos by the unyielding fortress of proper documentation. The trap had not just neutralized the immediate threat, it had permanently excised the liability from my financial ecosystem. Chloe was no longer a family problem to be managed. She was a state problem to be prosecuted. The transition from the polished wood paneling of courtroom 3B to the concrete reality of the county detention center was immediate and irreversible for Chloe. She was not granted special accommodations. The county processing facility operates on a rigid, impersonal algorithm designed to strip away civilian identity and replace it with a tracking number. She surrendered her beige blazer, her jewelry, and her shoelaces. She was fingerprinted, photographed under harsh fluorescent lighting, and placed in a temporary holding cell with individuals awaiting transfer to the state penitentiary. The insulation she had relied upon her entire life was completely gone. She could not negotiate with the corrections officers. She could not smile her way out of the intake protocol. She was processed as a standard liability within the penal system, forced to wear a standard issue uniform that offered zero distinction or comfort. The assistant district attorney did not offer a lenient plea agreement. The evidence was not circumstantial. It was entirely physical and thoroughly documented on the official court record. The prosecution possessed the forged electronic filing, the digital notary logs tracking the IP address of the submission directly to Chloe's apartment router, and the certified audio transcript of her perjury in front of Judge Harrison. Furthermore, they held the master deed of conveyance, securely vaulted by the court clerk, proving the undeniable ownership of Parcel 409-B. The grand jury convened within 72 hours. They reviewed the material evidence, analyzed the forged signature, and returned a true bill of indictment. Chloe was officially charged with felony forgery in the second degree, offering a false instrument for filing in the first degree and perjury in the second degree. Faced with this insurmountable wall of evidence, Chloe's public defender advised her that a trial would be entirely futile. A jury would simply be presented with the analog truth of the watermark security paper versus the digital reality of her tracing software. The statutory maximum for these combined offenses carried severe state time. The defender initiated a structured plea negotiation, hoping to mitigate the damage caused by her courtroom confession, advising her that pleading guilty was the only mathematical path to reducing her sentence. During this period, I initiated a comprehensive audit of my entire financial portfolio. I did not assume Parcel 409-B was the only target. I placed maximum security freezes on all personal and corporate credit profiles. I contacted the registered agents for my limited liability companies to ensure no unauthorized amendments had been filed regarding the operating agreements. I upgraded the municipal title monitoring service from a standard alert system to a dual authentication protocol, requiring a physical signature verification for any future encumbrances across all my real estate holdings. The breach had been identified and contained, but the perimeter required reinforcement to guarantee total future operational security. 3 months later, I returned to the county courthouse. I did not sit in the gallery. I submitted a written victim impact statement directly to the clerk of the court, focusing purely on the structural threat to my commercial assets and the calculated nature of the forgery. I detailed the precise market value of the land and the potential financial ruin that would have occurred had the county executed a foreclosure due to Jackson Miller's inevitable failure to appear. I did not attend the sentencing hearing in person. I monitored the docket electronically from the secure environment of my office. Judge Harrison presided over the final hearing. He accepted the guilty plea, recognizing her lack of prior criminal history but weighing the calculated manipulation of the judicial system. He addressed the court. He emphasized that fraud upon the court is not merely a crime against an individual property owner. It is a direct attack on the integrity of the institution itself. He sentenced Chloe to 18 months in a state correctional facility, followed by 3 years of supervised probation. She was also ordered to pay restitution for the administrative costs incurred by the county clerk's office to formally expunge the fraudulent lien. Jackson Miller, the catalyst for her destruction, received no benefit from her sacrifice. With his bail denied and his primary source of funding neutralized, he remained in county custody until his federal trial. He was eventually convicted on all counts of commercial wire fraud and sentenced to 72 months in federal prison. He never contacted Chloe again. The transactional nature of their relationship evaporated the moment she lost her utility as a financial shield. He moved on to identifying his next target from within the prison system, leaving her to serve her sentence entirely alone. Parcel 409-B remained entirely unencumbered. The 12 acres of commercially zoned land sat quietly near the interstate expansion, accumulating value, completely insulated from the biological failures of my extended family. The county clerk's office upgraded their verification protocols for property bonds, implementing a mandatory physical review of watermark deeds to prevent future digital circumvention. I returned to my bank branch and secured the master deed of conveyance back inside the fireproof sleeve of my safe deposit box. I locked the steel door, engaging the biometric scan, and walked out into the city. The financial fortress I had constructed was tested by the very people who should have respected it, and it held firm. The liability was surgically excised. The asset was secure. The perimeter was permanently sealed against any future familial treason. If your own sister secretly forged your signature and pledged your fully paid-off million-dollar commercial property as collateral to bail out her criminal boyfriend, how would you handle the betrayal? Would you confront her privately and risk losing the asset in a lengthy civil dispute? Or would you calmly walk into the courtroom, hand the judge the real watermark deed, and watch the bailiff put her in handcuffs? Let me know exactly how you would navigate this level of familial financial treason in the comments below. If you appreciated this story of cold, calculated, and institutional justice, drop a like, subscribe to the channel, and I'll see you in the next video.